So, thank you for coming this morning. It's good to see you all. A couple couldn't make it at the last minute, but that's okay. And we're going to talk about the very exciting subject of sick leave and long-term illness. The reason why we've selected this topic is because probably late last year into the early part of this year, we've had a lot of inquiries around this, especially long-term illness and medical incapacitation. So we thought we might go touch on it today. I'm Steve, know you all. Charlotte, I think Charlotte knows everyone. Yeah. So we'll get into it. We're going to make this quite interactive, so a bit of Q&A. And we've got a couple of case studies that we'll talk through. But we won't tell you who the companies are, obviously, or the names of the people. But just some kind of interesting things that happen within those organisations around particularly long-term illness.
I guess what I want you, or what both of us want you to be able to walk away today feeling confident about is the difference between short-term sick leave and long-term illness, because there is, and when to actually take action and why.
So I guess first of all, it's actually important to know why managing sick leave is so important. There's quite a few points here, but the main ones is that having so many staff off away sick actually does reduce your engagement and the staff morale between team members if there are those regularly occurring members of the team that are away sick. Lost opportunity and definitely lost profit and productivity. And out of the days that we actually have available in the year, obviously there's 365, but only 228 of those are actually available working days in 2023. And we've actually got some stats there that in 2021, when the number of sick days was 5 days available, the average number of days taken by employees was actually 4.7. So most employees are taking all their sick leave. And what we see, now the number's risen to 10, a lot of employees do see it as a target. So you need to factor that into your calculations as well. But there are a number of other reasons why it's important to make sure you're managing sick leave and staying on top of it.
Yeah, I think I'd just like to point to the very last point too. It's also about kind of the manager's well-being. Typically when people are sick or ill, then a lot of the responsibility falls back kind of on the manager to either kind of reallocate their work or pick up their work even, etc., etc. And so we see that in kind of a material or some impact on actually the manager have to manage people when they're off sick frequently. I think we need to say that if people are genuinely sick, they need to be off sick and they need to stay home. But sometimes I'm sure you've all experienced the pattern of sickness.
So today, things that we're going to cover, we have to cover the process at the beginning, but like I said earlier, we're not going to go into too much detail with that, and you have a handout that you can take away, which is very process driven. So all about short-term sickness, all about long-term illness, and then some case studies, and I think this is the most value part of the session today, because we can explain what the situation was in those case studies and what the actual outcome was and the pain points that they had during those times, because nothing goes perfectly to plan, and often when we get engaged it's not at the beginning when it should be. And so then we'll go into some more of a Q&A about common questions that do arise, common things that go wrong, and that's where we can just open the forum for your questions at all. And honestly, during today's session, just feel free to ask questions at any time. That's what we want it to be. So firstly, I'll quickly touch on short-term sickness, and this often rears its head when entitlements are exhausted, or there's an emerging pattern. So that's like often a Monday's off or a Friday's off work. So it might be the pattern of the same day or the same reason. So if it's the same reason, you might start to ask questions, well, do you as the employee need to actually go get a little bit more help? Why are you off for the same reason every time that you're sick? So what we suggest, step one, having that informal discussion with your employee. So on a very casual basis, just check in, because that's often when employees will actually be able to speak more freely or feel more comfortable rather than an initial formal meeting initially. Definitely refer to your IEA. So these excerpts on the right there are the common clauses that will be in the IEAs on HR Today. So that's what we suggest referring to. If your employment agreement does look a little bit different, always check the IEA first and any policies that may point you in the right direction, because if you don't follow that, then you definitely will get stung for the process. If nothing improves after that informal discussion, have a formal meeting. That might result in a warning or a letter of expectations, which some of you may be well aware of. Again, if there's no improvement, then that may result in a second formal meeting and further warnings and letters of expectations. I must just say that this does depend on the process. If you have a specific process outlined in your IEA, if you might have one more step in there than that, or you might have one less step, do make sure you follow that, but there are always situations, depending on the severity, that you could jump a step. Again, if there's further no improvement, then that will be one of the last formal meetings, when you'll likely deliver some sort of preliminary decision, which means that you deliver the decision, you actually have to seek feedback on that decision before making the final decision. And I think prelims are a very good tool in terms of sickness or medical incapacity, because they are very sensitive areas that are highly impacting someone's life. So to give them one more last chance to explain themselves or justify, just give them an opportunity to speak, is really important. So that's essentially the nutshell for the short-term sickness process. But as I said, you've got a handout that you can take away with you today, and then I'll just quickly touch on the long term. So this definitely presents itself a little bit different. Often you'll notice that you need to take action when there's significant time off work, but that can be just 5+ days in a row. Or usually when we see it, it's a couple of weeks, potentially a month that someone's had off work. Often there might not be a return to work date, and that's when that's essentially a red flag, when you really do need to start actioning some sort of process. And often they've exhausted leave entitlements. So sometimes I might see clients that have been managing a medical incapacity process. The employee could have been off work for a month. ACC's been dealing with it, and it's not until they might come off ACC and then begin to use their sick leave entitlements, then begin to use their annual leave entitlements, and that's when the client contacts us, because all of their entitlements have been exhausted, and now they're like, wow, we don't have money to pay them. How are they going to get paid? So essentially, step one, identifying the issue. So however it's reared its head, have a look at the employment agreement, like I just discussed before, to make sure there's not any particular process that you need to follow. For long-term illness, there are more particular clauses in our HR Today employment agreements, and those excerpts are on the side as well. Those clauses are a bit different to the ones for short term, because these give the employee permission to actually contact that medical practitioner and get more information that you need. Step 3 would be to meet with the employee to identify the ways that you can accommodate their needs. So it might be quite a simple change to their hours of work, if you can accommodate that, just for the time being, as long as you've got time frames that you can stick to. Obtaining medical evidence is very crucial. So your IEA might say that you're allowed to request a medical certificate, often it would, and that's what we'd recommend. However, the importance of medical evidence when it's long-term sickness is that you actually do have those return to work dates in place, and that's the most common occurrence that we see, is that there'll be a return to work plan, it'll be for 1 month, we'll get to the end of that month, and then it'll be another one, and that's what we'll go into a little bit more detail soon. You do need to consider those accommodations and see if they actually will work within the business, rather than, well, maybe it's a low performing employee, I'm not going to consider those accommodations. You can't do that. You do actually need to see what accommodations there are there. And the last step is considering termination if all of those other options are exhausted. But the one key takeaway from this slide with long-term sickness is to definitely action it as soon as possible. The longer you leave it, so for example, if an employee's been off sick for 2 months and then you're starting this process, they have a very strong argument to say, well, my role's been held open for 2 months, why can't it be held open for another 2 months? And that's a really fair argument on their behalf, so it's going to be quite hard to find a justification to terminate them. Now we'll get into the case studies, which are quite valuable and practical scenarios. Steve's one is first up.
Firstly, there is an employment law handbook, and the medical incapacitation section starts here and finishes about a dozen pages later. There's quite a bit kind of to it. And I think, and Charlotte and I were talking about this over the last couple of days, every case is different. You can't treat kind of every case the same in relation to this. And I think just what I find too is that sometimes there's a wee bit, and I know it's important too, but sometimes there's a wee bit of kind of mixing cocktails when it comes to long-term illness and people start talking about medical incapacitation. For example, I went out with Key yesterday or the day before to see a client we're just starting this process, and so the person had been off for a couple of months, but they're saying the person's was not performing, that we don't want the person back. So they stopped talking about the kind of medical incapacitation piece and it became about a performance piece. And so we're trying to kind of separate those two things because we either have to deal with one or the other. And that's often what we see, that sometimes that kind of starts to come into the discussion, other things other than their injury. So sometimes it's just about kind of stripping a bit of the emotion out of it and just focusing on the medical piece. This is an organisation we deal with, the construction sector. And the work that we're doing with them is kind of intermittent every now and again. But I had a call from the general manager, and it would have been kind of late last year or third quarter last year. They have about 27 employees. Most of those people kind of work outside the office, and in the office there's 8 to 10. There was a person who's in a role. She is one of 3 people doing the same role, essentially. And her injury is, she said, work-related. The organisation challenged that. It was like an OOS type injury, but it was actually quite a bad injury, and she had surgery on both kind of arms in relation to that. By the time when they called us, she had been off work for months. In the end, she was off work for about 15 months, and they've been holding the job open. So they called us, and we got involved probably after about 11 or 12 months in this process. So she'd been off work for a period of time. She had had a surgery, and then she was on a return to work program through a return to work provider that was going to last about 4 to 5 months. And then the employer at that point in time actually started, when we got involved, started to get involved, because up until then the employer was kind of managing this. They were managing it with ACC, they had a case manager, and they were managing it with the employer providing medical certificates. And the employer had no I wouldn't say no visibility, but they weren't kind of actively involved. The employer wasn't aware of what they were entitled to see. So they didn't know that they could contact ACC and get information about the employee's injury. They didn't know they were entitled to get some information from the specialist, and the person was going to a couple of specialists because of the nature of the injury that she had. And they didn't know that they could engage with the return to work provider, which you may have heard these return to work providers. If someone's got an injury, ACC might send them to a return to work provider who does these return to work plans. And so they're completely kind of in the dark in relation to kind of all of that. So the employer got to a point where they were saying, we can't hold this job open, we don't want it back anymore. By the way, 15 months ago, the 2 team members, that she was annoying them as well. We think we can find someone better. So it kind of, the whole narrative kind of shifted. And so we had to go back and say, let's just talk about the kind of injury. We got involved quite actively in the process. We got permission from the employee to access medical information. We got permission from the employee to engage with the return to work provider. We got permission from the employee to get have communication with ACC. And at that point in time, not going into all the nitty gritty, a lot of information kind of came to the fore through that kind of process. A couple of things there. ACC are quite difficult to deal with, not because the people there aren't trying to do their best, more about how they're set up. So, they've kind of moved from a case manager for every person to you go into a call centre and if you ring 2 times in 2 days, you get different persons, so you explain the same story to kind of different people, and so it's quite challenging. So we pushed it so this person got a case manager assigned, which was good. But in the end, she ended up coming back to work, but she came back to work a lot sooner. And it's because we put some appropriate pressure, both on the return to work provider, who had a plan that stretched out for months, and the person doing, to start with, 1 hour twice a week for like 2 months, something like that. It just couldn't be accommodated. So we put pressure on to say, well, unless, and the specialist confirmed this, unless we can increase that to something that's more, we believe, reasonable and manageable and appropriate for the employer, we might not be able to hold this job open any longer. But we're very cautious of that point that Charlotte made before. Because the job had been kept open for so long, it's hard for the employer to then go back and say, we can't keep it open any longer. Keep it open for a year, surely you can keep it open for another 3 or 4 months. And so we had to take that into consideration, along with putting an appropriate amount of kind of pressure on to try and get this person back to work, but ensure that that didn't mean that this injury was going to flare up or kind of reoccur. But I think the kind of key takeaway there is the employer was not in control of the process, the employer was in control of the process. The employer got the injury, left work, provided the medical certificates every month that she was required to do, went to the surgery, there's post-surgery things happening, and the employer was kind of completely in the dark around that, so the employer was managing it. And I can tell you she would still be on leave now if there was no kind of intervention. And I would say that if we had got to the point where we had to intervene, say, if we had been called in now and decided to terminate that employment, that could have got a wee bit sticky, I reckon. I think there would have been a personal grievance claim. I'm not saying the personal grievance claim would have been, fair or valid, or they would have got anything out of it, but it would have got just sticky because the job had been left open so long. So the employer was not involved in the process. They were relying on the employee to provide the information. Secondly, in this case, the person was on ACC. So when talking to the employer, when I was first talking to the employer, they were saying, we're not paying for this anyway. So the person became slightly invisible because they weren't coming into work each day, nor was the employer paying anything. So kind of partly in their mind is, well, it's not costing us anything. So it doesn't matter really. And I can see why they thought that, but it just caused kind of further issues downstream about whether they could take on someone to replace this person, etc. So they were kind of some of the key things in relation to that. But the key thing out of it was, it wasn't that we could have got to the point where we did terminate the employment, but the key thing was they just weren't involved in the process. And you are allowed to be involved in the process as an employer, so you have the right to be involved. You have the right to have access to medical records, right to access information from ACC and talk to ACC, right to have access to return to work provider and participate in those meetings as well, if they're kind of trying to get someone to come back to work. And you have the ability to, there's a bit of kind of caution around this, kind of engage with specialists if they're using specialists for some of their return to work or some of their support, as long as it's directly related to this situation or injury, not kind of other medical conditions that they might or might not have. Is that clear-ish? No?
It's quite a complex one, but do any sort of questions or need for clarity arise when Steve does go through that and explain it? So for example, I'd like to know, when you say you can talk to ACC and get that information, how do you actually go about that? Is that email, phone call? How did you get those contacts?
Good question, Charlotte.
Thank you.
Both. So once we told the person that we're going to be contacting those organisations, the first piece was on the phone, and that is slightly problematic because you can wait a wee bit of time, and then you phone again, end up a different person, and essentially explaining the same story and trying to get some kind of movement on this. I then made approach to the return to work provider, and we're lucky that there was one in play at that point in time, and they have probably better access to ACC. So I kind of leveraged off that a wee bit, and I remember having a couple of calls with ACC with the return to work provider, so I used that as kind of an angle to try and not sit there on the end of the phone. But then when a case manager was assigned, then I had the person's name and their email address, and I was kind of emailing them quite frequently. Although I did email them one Friday afternoon at 4:15, just any chance of a quick call to talk about this case before we kind of finish for the weekend, and well, I clock off at 4:30 was the response, and that was it. so anyway, bureaucracy. So I suppose there's different ways of accessing it, but it became easier when there was a case manager kind of assigned to it because you're directly contacting that person. But it's a bit of a squeaky wheel thing too. But the problem with that is if you're the manager managing it, it just takes time, and that's the part of the process that can be a bit kind of frustrating.
Thanks. I actually do have one more question because it is it's very different to the one that I'm about to explain. But how forthcoming was the employee during this process? Did that cause any issues for you, or were they quite open with all the communication and details and quite active at replying?
The employee is a very nice person, and the employee was very accommodating when the outcomes of whatever were being discussed benefited her. When there was some pressure applied, and appropriate pressure applied to kind of get the person back to work and kind of increase the number of hours that they were working and make sure that work was done from the workplace, not from home, because the home setup, there was a request to, now I need a laptop to work from home, and now I need, all that, but we kind of said no, it needs to be done from the workplace, etc. Then there was a bit more kind of slightly more kind of agitated, and so we played a bit of the good cop, bad cop. The employer being the good cop, and I was kind of the bad cop in relation to that. So when I go down there these days, I get 9 hellos and one, I'm stonewalled. So when we first got involved, the person was quite we got a wee bit kind of naily with the fact that the employer was bringing in someone to help with this process. And to be honest, her injury and surgery, there was quite a bit of rehab that kind of went with that, a lot of rehab that went with that. And so there was concerns for her that the employer was very kind of empathetic towards. But then after a period of time, she started to see I think the benefits of what the employer was trying to do. And ultimately, she said, I want to get back to work. And so there was kind of this kind of tipping point where almost, once we got through a bit of the kind of, the emotional kind of curve, she kind of got quite kind of engaged in it. Because what she could see is that if she didn't, they were going to terminate her employment. And she had been there for a long time, and she did a good job there when she was working, and she didn't want to leave. And so, but you kind of have to gently kind of, well in this case, kind of gently kind of get to that point as best you can, So the outcome was good, although there's still some people in the team don't get on with it. But each one's quite different. I think just have to kind of have the old emotional intelligence radar up about how to kind of, just work through some of these situations.
Absolutely. You're right about the tipping point. You definitely get to a fork in the road that it can go one of two ways. And it's all based down to that employee's personality and also how you're handling the situation as well. if you're being quite open and transparent with them rather than just with one agenda.
Yeah, this person was surprisingly kind of open, and they have to be open to kind of feedback, and they have to understand what the constraints are from the business, for the organisation. For example, the return to work provider, the starting point was, as I said before, like 1 hour every couple of days from home. But the impact of that was the employer would, because of the nature of the injury, was going to have to provide a chair, a desk, and a laptop, and was going to have to provide a headset and voice to text software. Now, the voice to text software was going to be covered by ACC. The desk and the chair were, but the laptop wasn't. And then the person was asking for their phone to be paid for, et cetera, et cetera. So we're able to kind of push back on that to say, look, there's some restrictions on that for a start that kind of can't be accommodated. And by the nature of the work that this person is doing, they actually need to be around other people, because some of the things that they're dealing with, they need to be able to talk to other people. And I know Teams and Zooms is great, but it only kind of goes so far. So it wasn't as if they can't work from home. It's just made it more difficult because of the nature of the work and some of the customers that they're dealing with. So we touted that kind of narrative, and so pushed back on that. So we got them to the point where, okay, we can do it from work. Then it was about kind of increasing the hours. And increasing the hours was to go in for 1 hour a day for a couple of days a week there's no benefit in that. So the person's going to have to drive in, find a park, walk down, say hello to everyone in the office. Well, there's 15 minutes gone. Sit down, set up, make sure the voice to text is working. Well, there's another 10 minutes gone. So we've got 35 minutes or 30 minutes, and they go walk out the door again. So there's no benefit of that. And so we kind of talk through that, and then what we managed to do, I can't remember exactly how it worked, but we managed to increase the number of hours on the day that she was in, not having fewer hours over more days, if that makes sense. So we kind of got to that point as a starting, and then we kind of worked from there. But then the other things, they had a 3-month plan in place, and it was kind of, so many hours a week for the first kind of, month, and then kind of increased by an hour for the next month. And we just said, why don't we go so many hours for the first 2 weeks, and then increase that for the next 2 weeks, and increase that for the next 2 weeks. So in the back, there's a return to work provider. Then there's the specialist who is approving some of this as well. So the return to work provider would go back to the specialist and say, are you okay for this person to do this? And they were kind of saying yes or no. So it was just me as the employer's advocate just suggesting other things, and they'd have to kind of, the specialist have to improve it. And if they came back and said no, then we might have said, well, okay, well that's enough. It's 1 hour twice a week for the next 3 months. We're not sure if we can hold that job open. Yeah, so it's just, you just kind of have to engineer your way through a wee bit, yeah. But I can't say, James, you're back to work, you've got to do 5 hours a day for the next 3 weeks, because I'm not qualified to do that. But you can just push a bit. Yep.
Yeah. Okay, well, my scenario is quite different to Steve's actually. Whereas I think that was a really good result in yours, and this was a good result in ours too, but for very different reasons. Compared to Steve's, the most significant issue here was the health and safety impact of it, and the crossover between awesome that they can return to work on light duties, but can they actually do their role? If something went wrong, where's the liability with the company? So with this situation, a bit of background, because you have to know the employee very well as well. The employee, he was with the company for about 8 years, and over those 8 years, he was a recidivist user of sick leave and injuries. So he's always got his sick leave blown out, and at least once a year, and I actually looked back on the calendar, at least once a year he would have some sort of injury, which I think is a whole nother concern in itself, but it definitely helps when you're dealing with this. So right there, he had 100 days off work over that last 12 months. So if he was lucky there for 1 in 3 days, it was nuts. But he was good at his role when he was there, but he was good at his role in terms of everything else, engaging with other employees, engaging with the company, not so good at. So when the employer engaged us, they already had in their head what they wanted to do. So it's our job to, hey, well, wind this back. We need to actually start from the beginning and make sure we stay on track and within the law for sure. The injury was a back injury and it wasn't related to work. And a lot of the time you'll find, ACC aside, whether it's work or non-work related, you still have to deal with it as the employer because it's still affecting their ability to do work. The company, unlike Steve's one, actually did keep the lines of communication open from the beginning. Their issue was probably with the employee responding back. There was one of the biggest issues here was the conflicting advice, and that's what I'll talk about quite a lot. Is when you've got the physio as the return to work organiser saying he's not fit to return to work, and then you've got the doctor saying whatever the employee essentially wants him to say, which was that he's fine to return to work. And I say that because 1 month in, he was not fit to return to work according to the doctor. As soon as we started a formal process, the doctor said he's fit to return, full duties, no worries. And so that's when the employer said, hang on, this doesn't seem right, there's conflicting advice. As an aside to that, there is a hierarchy with health professionals, and just so you know, what a doctor says does override what a physio does say. However, because of the employer's knowledge around the particular doctor and just the conflicting evidence, they decided to engage an independent medical advisor. But with one of those specialists, it takes 1 or 2 months to actually get an appointment, which you might be aware of if you try book into a specialist these days. So in that time, there was quite a process that we went through. Just a bit more background. With the doctor, when they did say he was fit to return to work, we, on behalf of the employer, requested evidence around why he's fit to return to work and what sort of notes were taken, because we had the report from the physio saying he's not fit for these reasons, but we didn't have any report from the doctor corroborating that. The relationship between the company and the employee absolutely became severed over that time. So in terms of the process, I'll just explain a little bit for you. We were probably engaged about 1 month in. The employer was communicating really well with the employee over that time. He had his first medical certificate. He was really good at getting his medical certificates. Once he got his second one and it rolled over, that's when we engaged and actually spoke to him, tried to find some solutions. He was very engaging with the meetings, but he wasn't engaging with solutions and those sorts of things. He just said, well, I don't know, I don't have answers. I'm scheduled to see a specialist for my back in about a month's time. We'll need to wait till then. And so it's really managing how long you keep that door open for. And it was very reasonable for us to wait for that outcome of the medical specialist. Also, what occurred during this process, when we were probably engaged for 1 month, which so had been away from work for about 2 months now, we had quite a few meetings over that time, probably about 2 or 3, which is quite a lot. So that was probably every week or second week. We met with him just to get updates. He then decided to get this doctor's medical certificate once he saw the process going a certain way that wasn't suiting him so much, and that we were really getting to the formal stage. I think at that stage we had invited him to a preliminary decision meeting because the employer had made a decision that they wanted to run past him in terms of his employment. As soon as we got to that meeting, we received a doctor's certificate saying he was fit to return to work, and that's when that opened another can of worms around asking for the details. What's really good to know, and Steve touched on this before, is the amount of detail you can actually request from a doctor. And in his employment agreement, he was actually on a collective agreement at the time, we can request as much as we want, and he's signed that agreement saying that we can. So we requested the information from the doctor, never heard a thing. It was a week down, okay, doctors are busy, we'll wait, see what's going on, and requested again, still didn't hear back. So we met with the employee, asked him what's going on, asked for his information from the doctor, and he said, no, I'm not giving it to you, I don't need to for privacy reasons, which you think is a valid response because privacy is held with quite high regard. However, his employment agreement says otherwise and he does need to give it, but due to the personality, we sort of just found our way through that one. And in that meeting, before he walked out, he mentioned, I'll leave for 12 months pay, right? So quite significant, because if you look back in any cases through the courts, it's about 3 months you might be lucky to get. So that was quite a bold statement, because it suggested he's checked out, the relationship has really been severed, and he really doesn't want to be there. We had to address that because it is quite a serious statement to make. So we had an appointment set for the independent medical assessment a month out. So we met with him to deliver the date, make sure he's available, check that he doesn't have anything else on, even though he was at home. And then we delivered that and also used that as an opportunity to respond to his offer, because essentially it was an offer. And this is a really sensitive subject, entering what's called a without prejudice conversation, because you can't coerce anyone into that. It has to be fully on their own accord. So how we approached it was suggesting that we understand that you put an offer on the table at last meeting. Would you be happy for us to enter it without prejudice so we can actually respond to that? And he was, because that's the whole point of the meeting that he was there for, because I was doing a lot of preamble at the start, highlighting the background of why we were at that meeting, and I think he interrupted about 3 times saying, can we get to the point, why are we here? So that was fun. Anyway, we got to the point and placed the offer on the table, and this isn't for everyone because every company is different. In order to get to this point, it did have to have board approval. They knew the background of this employee, so what they had to consider in actually deciding whether they wanted to even address the topic of an offer was, so if he came back to work, because this independent medical assessment was set for the next month, it could have said that the doctor's correct, he's fit to return to work. The employer would be in the situation, well, we need to put him back to work, but also at the risk of him taking sick leave again, him getting another injury, which is fully out of the employer's control, and just having to deal with that. And that's what they would do, because that's what a good employer has to do. So what they were weighing up was the financial benefit and also the well-being of the other staff, because retention's such a huge issue at the moment. The other staff there was already murmurings like, why is he away for so long? I don't want him to come back, that sort of thing. And not that you take that directly on board, but you take it on board in the sense, I need to retain my good staff, and the well-being of them is very important, and I don't want to put them at risk with having him back too early. So the outcome was presented to him. He said that he needed a week to consider it. We said you have 24 hours because you aren't doing anything else at the moment, so you don't need that long. And again, like putting pressure in the appropriate and correct amounts actually does help move these along, because he said, okay, 24 hours is fine. And he had a response to me the next day, and he took the offer and signed it in a record of settlement. And that's how that was dealt with. So very, very different to Steve's one, which I would say Steve's was a good result. The employee was back at work. This was a good result, just from a very, very different angle, and much more risk and caution had to be taken with this. Overall, he had about 4 months off work before there was a result. So when there was that conflict between the doctor's advice and the physio's advice, the company had to pay him. Whatever they defined it as, they had to pay him, because it was their decision to keep him off work because of the health and safety risk to having him back. And that was another consideration when they were considering the offer, was if he comes back, causes us some sort of health and safety incident, whether it's a near miss or a more fatal one, then they're the PBCU, and they have the responsibility there. At least they had everything in writing up until that point. So if something bad did go wrong and WorkSafe came onto it, they would be able to show why they did it correctly. And hey, here's a doctor certificate saying that he was fit for work. But they still didn't want to take that risk at the end of the day. What else do I have here? So yeah, the key takeaways is that health professional hierarchy with the conflicting advice, because that is something that we come into contact with quite regularly. In terms of, the company was entitled to seek specific dates from the doctor about the role and the ability to return to work, like Steve touched on before. You can go into really specific detail. An example of this isn't this case, but another one that I've dealt with just recently is the doctor's certificate said he can return to work on light duties. So we needed to know what those light duties were. How many kgs? So if he lifts cones for his job, can he do that? And when he does it, can he twist? How does he have to actually lift it up? Those sorts of details are really important. I know it seems so specific, but they are, because it also means the doctor actually knows you're taking it very seriously. And they will be able to write back saying, yes, he can do that. No, he can't do that. And it really helps with making a decision with whether they're returning to their employment or not. And the last takeaway is just that everyone's personality is very different. And you do have to manage it very, very closely. And if they didn't manage it so closely and kept on communicating him, kept on asking him questions, I don't think they would have got the same result if they had left it for 2 months before talking to him, or 1 month because he was on ACC. They really wouldn't have achieved the same result. So yeah, very different. Health and safety, when that gets involved, companies take it very seriously, obviously. But that was the main concern here with him actually returning to work and managing staff morale and the company. And the team's going great now. So it was a good result in the end.
I've got a couple of questions.
Knew you would.
So the GP said the person was fit to return to work, and you mentioned that then the employer was having to pay. Is that because as soon as the GP said the person was fit to return to work, ACC stopped paying?
Correct. Yeah, ACC stopped paying, and we see this far too much, to be honest. When ACC does stop paying, the employee wants to return to work as quick as they can, because financially it's not viable to be at home.
And because the employee didn't want the employee at work, they were having to pay him then? Yeah,
it was the employer's decision to keep them at home, and that was purely out of health and safety because they didn't feel that the result was fair. Although looking back on it, they would be covered by that result, they just still didn't want to take that health and safety risk. But yeah, if you make the decision as the employer to keep that person at home for longer for whatever reason, you do have to pay them for that.
What was the reason for the GP saying that the person was fit to return to work when the physio suggested they weren't? Because there's kind of a bit of a story around that too, isn't there?
Yeah, well, from memory, there wasn't any reason. And that was the whole thing. We needed the reason. We needed to see the notes. to justify that. There was much more background, as you can imagine. So when I was in one of those final meetings with the employee, he raised things, and this is why the relationship was quite severed. He raised things such as, well, the HR person, not myself, the other one, for the company used to work at this return to workplace. They have a relationship, and that he just stopped there and asked, what are you alluding to here? Because the process has been done very correctly. There is no conflict of interest whatsoever. But it just shows how his personality and the relationship, the trust with the employer was absolutely severed at this time. But those are questions that absolutely come up in those conversations, and you've just got to be aware and know what is going to be asked when you go into those meetings. But given there's such difference between advice, like it was a huge difference saying you can fully return to work and you can't at all. There was such a difference. It wasn't just light duties and you can fully return to work. So I think the employer made the right decision at the end of the day. And in their head, they got a great result for what they wanted as well. And they've also learned what to do and what not to do with these cases and the red flags arising in the future. And I think once you deal with one, it educates you so much for what to look out for.
And the person was on a collective agreement, so part of the union. What was the union's involvement in the process?
With a union, it's when you draft up an invitation letter for a formal meeting and those sorts of things, you say you have the opportunity, just like a normal employee, to bring a support person, but also bring union representation. And that was in writing all along. So there's only so much we can do to involve the union, and that's all we legally had to do. It's on that union member if they want to engage the union rep to help them. It wasn't until I got a phone call from the union rep the day of our final meeting saying, I haven't been aware of this, I don't know about it. And it's a bit of an awkward one because it's like, well, the employee needs to involve you, I don't have to involve you. And often when you do, there's just another person in the room. So how do we deal with mental health and long-term illness? Is it dealt with in the same way? Mental, in my opinion, is more long-term. And from what we've dealt with, it's more long-term. It's not like you're off for a week, you're healed, back to it. It's long-term in the sense you do need to make those accommodations because it might be over 3 months that you need to maybe just have regular check-ins. That might be the only accommodation that's been made to make sure there's any further support that needs given, or if you have like EAP services and those sorts of things. But also we have dealt with medical ones where the person wants 2 or 3 months off work, and it is dealt with in the exact same way. You still meet with them, try find solutions. I would say it's much more difficult because it's not seen as a physical issue. It's unseen, so it's even harder to deal with, and only the employee knows how they feel in that situation. With life pressures such as the flow-on effects from COVID and inflation, we've definitely noticed that more and more mental health issues are arising in the workplace. So how do we approach these situations when staff are coming to you and saying that work's actually causing their mental health issues? My initial advice with that would be it's more performance work related than the employee's fault potentially that they're getting burnt out. So have a meeting with them, discuss what changes you can put in place to reduce their workload and those sorts of things, or give them some time off to initially see if some changes can be made, because it may be a resourcing issue, or it may be that they can't cope with the expected workload, and that could be performance as well.
I think what we have seen over the last couple of years now is a lot more questions and concerns coming in from employers, and rightly so. People kind of, you speak to so many people last year and they say, God, I'm frazzled, it's the end of the year, thank goodness it's Christmas and that sort of thing. So I think those kind of impacts of even before COVID, and you kind of come through that, and families, and then it's pretty challenging for people at the moment just with inflation rates. So all that it's kind of adding to the mix. So we see and hear from a lot more employers in relation to people kind of struggling on that front. So how you manage that here is the challenging thing. I think as an employer, if you start talking about medical incapacitation, well, before you even start talking about that, it's about what as an employer can we accommodate, and is it fair for the person to say that their stress is caused just as a result of work? And so is it that person saying it, or is it everyone else saying it as well? And I think there's kind of two different things there, but we're all wired differently. So that's not to say that if one person's feeling it, it's not necessarily, it could be the result of work, but it's kind of asking yourself some of those questions. If there is someone that has struggled, then it's about, as an employer, if there is some work-related things you think might be contributing to that, well, what can we accommodate within the workplace and for how long? And kind of start asking those questions. But you might end up at a point where you've tried to do as much as possible, whether it's EAP services, whether you've changed the hours of work, which typically people don't like, because you're trying to accommodate to say, well, if work's causing you stress, why don't you go from 40 hours to 25 hours? But they can't. So there's that kind of comes into the mix too. But you maybe have tried some of those things. Maybe it's a change of duties. Maybe it's a change of job, if that's possible. But sometimes they might not want to do that because it's moving from on the computer to lifting things out the back, and the pay rate might go from $23 to $22 or whatever it might be. But then you might kind of get to a point where you start kind of entering into this kind of discussion, but you kind of have to kind of ease your way into it, because if someone's got a broken leg, it's quite easy to see. But mental health is just a different kettle of fish altogether. So kind of entering into discussions or process around medical incapacitation might just take a wee bit kind of longer. You might have to be a bit more kind of just a bit more careful going into that. And that's why kind of sometimes employers get to the point where they hate doing it, and you can't, Charlotte used the word, coerce someone into a conversation. But if there is a dispute between an employer and employee, if I say to Charlotte, this place is causing me a huge amount of stress, and it's because of what you're doing, blah, 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 and Charlotte disagrees with that, we can have a kind of a conversation. We can, as the employer, if Charlotte was the employer in this case, we can have that conversation, because I've opened up the door to have that conversation where there's kind of a difference in kind of opinion, or there is a dispute. And so that's why employers do go into those without prejudice conversations, and they kind of have to take deep breaths a wee bit and say, well, this is not working for either of us. There's one or two things we can do here. Maybe you look for a job elsewhere, and we'll help you do that by giving you, a month's salary. So it gets to the point where you can start having those kind of conversations as part of a process if the opportunity presents itself. But every person's going to be different. So you may be thinking of someone right now, and so how you deal with that person and how you deal with me who comes to you with the same challenges could be completely different. And some of it depends on kind of what outcome you want from it. We always often start with the question, what outcome do you want from this? And if it's, we want the person here, we want them to stay for another 3 years, and we want them to be, do the best that they can all of the time, but we need them, to be, in the right frame of mind when they come to work. So, well, how do we kind of work to that as a starting point? Others come and say, look, we'll accommodate this for 2 years. It's becoming kind of incredibly challenging for us as an employer and for other people that are employed here, and that might be addressed slightly differently. But as I'm speaking, I'm thinking of some other places that we're dealing with. We've got this sort of thing, and it's really challenging. Charlotte and I are involved with kind of an investigation at the moment with quite a large employer. Just thinking about some of the parties that are involved in that as part of the investigation around the kind of mental health challenges that are happening that have led to this investigation, and it's really quite complex, and there's no kind of easy answer to it here. I think it's just about starting and then seeing where that kind of leads to. But there's lots of expectations on employers these days about the support that's provided. But like there's a lot of expectation on teachers and schools about what they do as well. But I think it's just about putting a line and saying, right, we're going to start something now, and have some milestones and some gates along the way, and they might get to a kind of a point for you and say, we've got to see some shift by this point in time, or we might have to try something else, and kind of communicate that with the kind of individual, just so kind of everyone's kind of quite open about it. And those gates could be in 2 weeks' time, or it could be in 2 months' time. But it's probably it's kind of a situational thing.
How long do we need to hold their job open for? Very situational. And the main considerations for this, if you are considering termination, is how long someone's been employed for. So with my example, the guy was there for 8 years, and that's quite a significant amount of time. He's contributed a lot to the organisation over that time. Other things is how easy is it to fill the role, or how critical that role is. So, for example, a very technical labourer of sorts might be very hard to come by in a certain industry, so you might give more consideration to holding the role open for a bit more longer than you would for a different employee in that business, and that'd be your justification.
In relation to this one, people have to be responsive. They have to be responding to you. They're on leave, they're still employed. So if you've got expectations around, we want to have a kind of a check-in every 2 weeks to see how things are. Just let us know if you need to run off. I know we've just gone over time. You need to be communicating with us, etc., or making sure you provide your medical certificates on time. We see some situations where the employee kind of goes into a kind of a communication kind of black hole, can't hear anything back. And so if someone did and they're non-responsive, then you can actually you potentially could start another process, start a misconduct process. You might say, we're going to start a misconduct process, you're on sick leave at the moment, so we're going to commence this because of these reasons when you get back to work. That fires up people pretty quickly. Yeah,
so the main things to take away from here, and I hope you do feel a bit more confident around mainly just identifying when you need to start a process, because all of you can call us at any time and say, hey, this is a bit of a red flag to me. Should I start anything now? What should I do? That's exactly when you should call us. Make sure there's something in the IEA. Obviously, start the process as soon as possible. Even, Mel, it's like just having that conversation and just noting it down, time-stamping it that you've had it. You can still do that with informal conversations. You can request so much more information than you think you can from the likes of the doctor or the employee. When there's conflicting information, there is that hierarchy. And just maintaining that regular communication, like Steve's one, don't forget about them because ACC is paying for it for a couple of months. Make sure you still are in communication with them. But yeah, that is all from us today.